Finally, in a third sex discrimination case, the odds don't look so favorable for workplace fairness. AT&T Corporation versus Hulteen involves amendments to Title VII, the Federal Employment Discrimination Law, that are contained in the Pregnancy Discrimination Act of 1978, or PDA, which Congress passed to say, yes, pregnancy discrimination is unlawful sex discrimination. AT&T uses what's called the Net Credited Service System, or NCS system, to calculate levels of retirement benefit. Basically, what the company does is it calculates your seniority based on the date you were hired, but they'll move that date forward for leaves that you took, unless the leave is when you get credited for that absence. Prior to the enactment and going into effect of the PDA, AT&T said, well, for your pregnancies, you can only get 30 days leave, even though it didn't impose such an across-the-board cap for other disabilities that might occasion longer absences from work. What happened then is that Noreen Hulton retired from AT&T in 1994, after the PDA was in effect, but she wasn't credited for 210 days of leave following a pregnancy and ensuing surgery, and as a result was given lower levels of retirement benefits by the company. She sued, arguing that this violates Title VII as amended by the PDA. Now, you might remember 2 years ago, because there's been a lot of action in Congress on this, the Supreme Court, in a case called Ledbetter versus Goodyear, said that the plaintiff woman there could not sue under Title VII for discriminatory pay she was receiving because of sex discriminatory performance evaluations years earlier. The court 5-4 said that merely gives effect to past discrimination, but using currently neutral practices, and didn't violate Title VII. In contrast, here in the AT&T case brought by Noreen Hulteen, the Ninth Circuit said this is present-day pay discrimination. She got her retirement level calculated at a time after the Pay Discrimination Act was in effect, and she filed suit in the appropriate time, and so she could sue. The Supreme Court granted AT&T's petition for review, which unfortunately was supported by the federal government. Couple that with the fact that our Ninth Circuit Court of Appeals is the most reversed federal appellate court, and it doesn't look very good for Noreen Hulton or the many, many women workers of a certain generation who may have taken pregnancy leaves prior to 1979, January 1, and are now coming of retirement age. This case will be heard in December as well. An important civil rights case concerning possible constitutional violations in the investigation of 9/11 is Ashcroft versus Iqbal, I-Q-B-A-L. This case from the Second Circuit arose when a Pakistan citizen and lawful U.S. resident, Javed Iqbal, was arrested on November 2nd, 2001 on initially federal criminal charges, held in Brooklyn, then designated as a person, quote, of high interest in the 9/11 investigation. He was then put in a maximum security housing unit. He filed a lawsuit against then Attorney General John Ashcroft and FBI Director Robert Mueller, alleging that he and countless others were unconstitutionally profiled in the 9/11 investigation because of their religion, Muslim, because of their race, Arab, and or nationality, in his case Pakistani, and subjected both to classification as high interest and harsh treatment that others were not subjected to. He sued these high-level federal officials that he believed were responsible for this policy directly under the Constitution for violating his equal protection rights. The Court of Appeals rejected Ashcroft and Mueller's attempt to get qualified immunity and boot the case out at the very beginning of the lawsuit. They said Iqbal's complaint was plausible in context and noted that our federal rules for civil lawsuits only require enough factual allegations in a complaint to give the defendants notice about what the lawsuit is going to charge them with. The defendants, supported by the federal government and by an amicus brief by 5 former attorneys general of the U.S. from both Democratic and Republican administrations, have asked the Supreme Court to hold that in order to sue this kind of high-ranking government official and defeat their request for summary judgment, Iqbal should have to provide more detailed factual allegations. This is a problem, however, because that kind of factual detail that they're asking the court to insist on is often not available until plaintiffs get allowed discovery into the records that the other side has. The fact that the court has granted review, as well as the nature of who's lined up against him, makes it likely that the court might make it much harder for plaintiffs to sue, even in cases that might be constitutionally meritorious. This case is also going to be heard in early December. I have just one more to talk about this afternoon before Alan Hoy will field some questions that you've submitted on cards, and if you have more, you can. This is one last civil rights case I'll mention, Haywood versus Drown. The case arose after Attica prison inmate Keith Haywood tried to sue different correctional employees for money damages for allegedly violating his constitutional rights. He filed suit in state court under 42 U.S.C. section 1983, the statute that people usually use in that kind of case to sue state and local officials for constitutional violations. But New York State has a law that forbids suits against correctional system employees for money damages in state court, requiring them instead to sue the state itself in a particular court or to go into federal court, which might be harder for someone to do, especially if you're in jail and can't get around very easily. New York's highest court, in a split decision, 4-3, said this was okay because it didn't discriminate against federal claims as opposed to state law claims for damages. Haywood, the inmate, said, no, this doesn't count as a neutral rule. It's not simply like dismissing a suit because the forum is inconvenient and everyone else or all the witnesses are in some distant location. Rather, this is an attempt to confer immunity on state officials from 42 U.S.C. section 1983 lawsuits, and federal law doesn't allow a state to do that. The Supreme Court granted review, and this case is going to be heard the first week in December. There wasn't a real split among the lower courts on this issue. One of the things the Supreme Court often looks for when deciding what cases to consider on the merits. New York's rule is basically unique, so maybe we'll get some good news from the court and a ruling that will help keep courthouse doors open for constitutional claims by some of the most vulnerable among us. Whether or not any of these cases bring good news for civil libertarians like us, they do underscore the vital importance of the composition of the Supreme Court to constitutional rights, and therefore the importance of the philosophy of those who appoint and those who confirm Supreme Court justices as far as the strength of our Constitution and its enforcement are concerned. So it's very encouraging to see so many of you taking an active interest, and I would encourage you to make your views on these kinds of issues known to your elected representatives and to vote accordingly.